My name's Jeremy DeBeer. I'm a professor at the University of Ottawa Faculty of Law. That's Canada's largest law school. And at the University of Ottawa, I teach a variety of courses, including first-year property law. I teach seminars on intellectual property in the music industry, intellectual property and environmental law, and intellectual property advocacy. I'm also an active researcher. My research interests are in international trade and development. I'm particularly passionate about the continent of Africa and have a number of research projects and interests between Canada and Africa. I work on technology law and innovation and intellectual property. I also have a part-time legal practice. I don't do solicitor's work, but I've been a barrister and solicitor, a member of the Law Society of Upper Canada since 2002. That's the governing body that represents lawyers in the province of Ontario. Most of my practice focuses on appellate litigation, public interest appellate litigation in the Supreme Court or Court of Appeal, and translating academic research into legal policy advice in areas like intellectual property or marketplace framework regulation. So that's a little bit about my background in terms of education and research and practice. I also have done a significant amount of work at the intersection of law and a discipline known as futures studies. And I have a number of publications that I'd be pleased to share with you if you're interested afterwards. The comments I'll make today as an introductory remarks are drawn from my research in the area of law and futures studies. One of the first points I'd like to make is that in this field, we speak about futures in the plural, not the singular, recognizing that there are inevitably multiple plausible scenarios, different futures that we might face. If you think about the way that economists or meteorologists contemplate the future, it's predictive. It anticipates what's likely to come by extrapolating on past trends or applying particular models. And in a way, lawyers think similarly. We are trained, and in practice, we provide clients with advice predicting typically the most likely outcome based on past experience, based on precedent. Futurists approach the future or futures differently. Rather than trying to be predictive, in the field of future studies, the goal is to anticipate multiple plausible scenarios. And the purpose of doing that is to be able to identify signposts on the way to different futures and to shape futures from a range of plausible scenarios to a narrower range of preferable scenarios. So that's some of the work that I've been doing in the area of law and future studies. I'd be pleased to speak to you about any one of the areas I mentioned earlier, my experience in legal education or some of the research topics that I've been working on in technology and international trade and development and intellectual property, or some of the recent issues that I've come across in legal practice.
Thank you. I'm interested in the signpost analogies. Which way are they facing and what are they saying?
One of the first things that we do when we construct scenarios is identify drivers of change. And these are major social or economic or technological or environmental forces that influence the direction of the future. In our field, there are a number. One of the most significant, I believe, is globalization. That's the topic we're here to talk about today. It's important to recognize that these forces can work in multiple directions. We can see increased standardization and harmonization in legal regimes worldwide through international treaties or trade agreements or even practices. or we can see an increasing amount of fragmentation and variation and differentiation. And it's important, in my view, not to presuppose that we're moving only in one direction. We may see different forces at play in different areas, different substantive areas of law, different jurisdictions might have different relationships where you're moving closer together in some respects and further apart in others. I think the changing nature of professional regulation is also important, as we see different structures in place for legal practitioners, increased foreign competition, increased variability in models of structuring legal services as clients' demands change. Of course, artificial intelligence, data, and the like are important drivers of change. One of the things I would suggest is valuable to do is to look at the intersection of those drivers of change as opposed to considering one factor in isolation. So, for example, if you imagine a world in which we see increasing homogeneity in terms of legal standards, take a field like intellectual property in particular, you can imagine how that might intersect with artificial intelligence, a world where legal advice is increasingly provided by machines. In a situation like that, we are likely to have a relatively well, you could imagine a situation where we're hailing our computer overlords. We have standardized legal systems and artificial intelligence providing advice. But you can also imagine different intersections where, rather than increased legal standardization, we have increased fragmentation. And rather than legal services provided through artificial intelligence, we're in a scenario where in some areas the human touch is absolutely essential. And in an environment like that, where we see increased fragmentation and a human touch, we may be in a more business as usual situation where the role of lawyers is not as changed as radically or as fundamentally as we might believe it is.
One of the issues that we're looking at here is the increasing availability of commercial documents available on the internet. Provide your credit card and you download a joint venture agreement or something like that. And the issue is, well, are those who are providing those documents in effect doing legal work or not? Is that something that's been looked at in Canada?
I can't speak to that issue specifically, but it is something that we're preparing our students to deal with, and I prepare my students to deal with this situation. And so the way that I approach this in my classroom is to emphasize the development of critical reasoning and critical analytical skills, essentially going back to first principles from a pedagogical basis, because if you are able to sort of purchase documents like a joint venture agreement, or even on a simpler level, a will or an employment contract, those services can be commoditized, but the analytical skills that a lawyer can bring to a relationship between parties are less easily commodified and replicated. So I think those skills are increasingly important to instill in our students as we prepare them for the legal practice of the future.
And is there an Uber-like event coming over the horizon as far as you're aware, or will we only know about it when it actually arrives on our doorstep?
Well, one of the things I'm very fond of is a law of futures promulgated by a person named Jim Dator. His second law of futures is that any useful statement about the futures should appear to be ridiculous, and that if the statement isn't ridiculous, it's not particularly useful. And so to tie that into your question, I think, of course, there's a massive disruptive force coming. But rather than attempting to try to predict precisely what it might be, what that disruption is going to be, I think we're better off anticipating a range of multiple plausible forces and trying to think about how they might intersect on a more fundamental basis, how we're going to prepare for disruption in general as opposed to a particular disruption.
And how do you prepare your students for postgraduate life as lawyers with that in mind?
Well, I mentioned earlier some of the pedagogical strategies I use, particularly in my first year course, ensuring that students have the analytical skills and the awareness of first principles to be able to work through problems. I also think mentorship is increasingly important, and so I pride myself on working closely with a small group of students who are members of my research team, who work with me in some of my seminar courses on intellectual property advocacy, for example, because that type of mentorship can yield really lasting dividends. And so it's not as much about the content that's being taught, but about the relationships that are being cultivated. And one final point I think I'd mention is that we're increasingly focused, particularly at the University of Ottawa, but at law schools across Canada, on the issue of diversity. As the face of Canada is changing, it's increasingly important to ensure that our student body is reflective of the diversity that we see in the country, so that we can create a legal profession that is more reflective of and better able to serve the community. And so that has implications in terms of the demographics, the makeup of the student body, but it's also important in terms of the topics that we teach. We have been challenged by the Truth and Reconciliation Commission in Canada to change the way that we provide legal education and to do a better job of ensuring that Aboriginal legal traditions are reflected appropriately throughout the law school curriculum, and that's something that many law schools in Canada, the University of Ottawa in particular, take very seriously. And so I think that's also quite important to prepare students for the future, is an increased focus on diversity.
One thing I was wondering is, as well as teaching your students about the importance of analytical skills and first principles, what do you do with them around things like resilience and getting them comfortable with things being ambiguity and situations not being certain? Because many lawyers want to have a nice outcome, and when they can't get an outcome, they feel uncomfortable in the absence of that.
This is one of the reasons I'm somewhat more skeptical than some others about the threat that artificial intelligence may pose to the legal profession, because I think ambiguity is an inevitable feature in a legal system. Anytime you're attempting to arrive at just outcomes, there's a degree of social context that can't be coded as easily as we might think it is. Now, if you're talking about standard commercial transactions, blockchain has the potential to provide that trust that lawyers and legal institutions have historically provided. But in other areas, there isn't that replicability. And so one of the things that I try to instill in my students is to embrace the ambiguity and to appreciate that with a law degree and with participation in the profession comes tremendous responsibility and privilege and power to resolve those ambiguities in a way that advances the causes of and promotes social justice. So rather than accepting a particular legal outcome as inevitable or certain, the ambiguities in the law can be used to advance particular positions and to change power structures. I think that's important and empowering for students to realize.
But change can be also confronting for those who are more mature. And is there any insight that you can give into the way in which the profession in Canada is dealing with the impact of change on those who are potentially or are in fact being left behind, not able to cope with the situation?
Well, I think you see in general different attitudes regarding the nature of legal practice. I think we're seeing increased emphasis on work-life balance, and that we have to adapt to that in order to ensure that we as a profession can be accommodating of people with different needs and in different circumstances. And that is something that's on people's radars.